Next to be interviewed, Your Honors, is Sandigan Bayan Associate Justice Alex L. Quiroz.
Good afternoon, Justice Quiroz. I hope you are well prepared to answer all the questions of the members. Okay, so please sit down. May I request Attorney Cayosa to start?
Thank you, Madam Chairman. Good afternoon, Justice Quiroz.
Good afternoon, Your Honor.
Yes, we have interviewed you several times before, but let me just pick your brain and find out your thoughts on some of the issues affecting the legal profession and the judiciary. First of all, do you feel that, do you believe that the compensation of judges and justices of the judiciary is sufficient? Or should the government increase the salaries of the members of the judiciary?
Should I use my yardstick, I would like to say there should be an increase. How much should a judge having an average of 3 children and that the tuition fee of those 3 children will have at least from 80 to 120,000 per annum. That's 3 school buses, and then their daily subsistence, including the expenses of the couple, the parents, I mean.
But when you apply to become a judge or justice, you already know how much compensation you'll be getting.
Yes, Your Honors, I was so fortunate because, modesty aside, I inherited so much from my parents. So, insofar as I'm concerned, I don't have any problem. But I would like to speak for and behalf of the majority.
Corollary to this, some of the LGUs provide an allowance for judges and justices. Are you in favor of this?
No.
Could you tell us why? Why not?
First of all, whether we like it or not, it would one way or another influence the relationship, or even might create a sneaking suspicion to other litigant lawyers agreed by the LGUs. So, without awaiting perhaps a remedy, the question, may I now suggest a remedy, which I already submitted my position paper then to the Supreme Court, that if possible, at least a station will have a retention of 5% of the JDF that have been collected by that station, so that the same will be used within the station. That's
okay. But wouldn't that also be arbitrary? Because in some stations, there's 0 cases filed. So they may not enjoy the same benefits as other judges in other stations that have a lot of cases filed, and therefore JDF would be higher.
Yes, I agree with it. But just what, say, I would like to compare it in Bataan, where I came from, and the NCR, say, in Makati. Well, the judges, the requirements of the judges would require more than the judges stationed in Bataan. That's it. Because during my incumbency, it's still, should there be a bulb to be replaced, I have to go to the Supreme Court. My station is merely in Pasig. I am now imagining, what if my station is in Bataan? Perhaps the transportation might be cost higher than the necessity.
On another topic, specifically on ASEAN integration, one of the effects of ASEAN integration would be to liberalize different practice of professions, including the legal profession. What do you think should this be regulated, the practice of foreign lawyers in the country, and how should it be regulated? And what would you propose if you become a member of the court for the regulation?
Well, of course, just like at present, the practitioner is being controlled and regulated by the IBP. Perhaps we will have another body that would be the one to control it. How should we control? First, there should be a requirement as to the updating of their laws, as well as if possible, the ethics. Okay, that these foreigner and us, vice versa, or in our counterpart, to have an arrangement insofar as the culture and what are the laws to be followed, and there are perhaps some conflicting laws applicable between countries, such as one country might be imposing that penalty, while in the Philippines we held in abeyance the imposition of that penalty. That's it.
With respect to regulation, we were thinking in the lines of the limitation that is going to be imposed on lawyers, foreign lawyers, such that, for instance, they would be limited to practice their own law. So, for instance, a Singaporean can only give advice with respect to Singaporean law and not be allowed to appear in court. So it's a very limited practice. What are your thoughts on that?
Well, initially I will agree with that, but perhaps due to a growing education and because I always maintain the dynamics of a law, that it must adapt to the necessity as it is being required by the time, Your Honors.
Should we be pressured by reciprocity? In Singapore, there is no limit as to what a foreign lawyer can engage. In fact, like they're very open. They're very open to all aspects of the profession.
Well, I would like to think insofar as its economic impact as to the law profession, as well as what would be the ethical effect among lawyers locally and foreign. That's why those, I think, although I agree to have that regulatory body, but as to the specifics at this time, perhaps there's a need to study more on that point.
My final question, Justice.
Yes, Your Honors.
What were your thoughts when you learned that your colleague in the court, Justice Ong, had been dismissed from the service?
Well, first of all, the decision of the Supreme Court, as it was penned by Justice Gutierrez, it gives us a sounding lesson to be upright and you have to follow the judicial ethics, as well as the restrictions imposed for every magistrate from the first level court up to the highest court. That standard. But personally, having known Justice Ong, perhaps about 1985, when we were been together at the City Fiscal of Manila, well, personally, that's life. My feeling is just the same. He's a colleague, that's it.
As I mentioned, it was my last question, and we have extensively interviewed you before, so with that, I wish you luck. Thank you, Justice.
Thank you very much.
Thank you, Madam Chairman.
Thank you so much, Attorney Cayosa. May request, Attorney Mejia. It's your turn.
Thank you, Madam Chair. Good afternoon again.
Yes, Your Honors.
Justice Quiroz, this is the 8th time that we're interviewing you. So I will just ask the questions that were tweeted earlier, and some of which were asked other candidates. What's your religious belief, and does it affect your disposition of a certain case?
I claim to be very religious. Every day I go to Mass. However, as I have learned from the teaching of the Church, give to Caesar what is due to Caesar, and give to God what is due to God. One proof is, perhaps I might be a presiding judge who have imposed death penalty for several times. Not once, not twice, but about 12. So we have to distinguish our faith. And if my faith will contradict a law or being a magistrate, I have to resign. But for the meantime, though I practice my faith, I still maintain I could separate my religion from my career, Your Honors.
Does greater transparency in the judiciary compromise, including its budget, compromise independence?
I would like to answer it. Transparency meaning how should the court spend its money, but it might should it be that way, it might sacrifice its independency. However, I still maintain that our judicial system or our court is being run honestly. So there's nothing wrong for me. But transparency, should it amount to a restrictions or limitations in the exercise of the court of its judicial function, I will disagree. But would it not hamper the efficiency of the judiciary, then there's nothing wrong, as long as it would not limit or impose restrictions on the judiciary, Your Honors.
For my final question, again, this is a tweeted question. Do you think the JBC has effectively depoliticized the selection process to the judiciary, and what reforms to your mind are required?
Well, I would like to answer it. Should I compare the GBC to a commission on appointment, I would opt to choose JBC because traditionally in the commission on appointment, political horse trading play. Here, it's due to a Filipino tradition. We cannot avoid some little favor. Sometimes it is your professor, sometimes it's your fraternity brother. Wherever you go, a Filipino has its own character, has its own good character as far as I'm concerned. So, reform, perhaps, no offense meant. I would say, I hope I'll not be offending somebody, the renewal of the appointments of the member of the JBC. JBC members, should I suggest, should only be appointed once, just like the COMELEC, the COA, to maintain its integrity, and to avoid a suspicion that there is a political horse trading between the member of the JBC and the one who is going to reappoint that member, Your Honors.
Well taken, Justice Cruz, Justice Quiroz, and good luck. Thank you, Madam Chair.
Thank you so
Thank
much,
you.
Attorney Mejia. And now, may I request again Attorney Guevara to continue.
Thank you, Madam Chairman. Good afternoon, Justice.
Yes, Your Honors.
Justice, I'd like to find out your purpose in seeking a position in the Supreme Court,
Well,
considering that this is the first time that I'm interviewing you, sir.
my purpose, Your Honors, I mustered the courage to apply to this position due to my vast experience. I started my career when practically I was newly a lawyer. I started it with the prosecution, okay, and then later on, upon request of Speaker Mitra, I went also to House of Representatives for a while, and then I joined the OSG. And then from MTC up to my present position. Now, modesty aside, I would like to think seldom I would see a lawyer in this career having an experience as a solicitor at the same time as a prosecutor. I would always see a former PAO and then a prosecutor, but not necessarily a solicitor. So, with humility, I would like. I feel I have to grow. I have to grow because of my exposure. I have a chance to have an oral argument before the Court of Appeals or even to the Supreme Court for a very limited, but I have that. And again, if my memory will serve me right, I don't have a backlog. I don't have a pending. When I was elevated to RTC, I think my pending in MTC is merely 60 or 50. When I was elevated to Sandigan Bayan, I think it's below 50. I don't have any backlog. Now, I have a zero backlog. So, I would like to think, it seems, there seems to be, well, although I graduated from MLQ, I don't have that good grades, but the judicial wisdom coming from my experience, I claim. So, I decided to apply to this position, Your Honors.
So I understand that that is your principal consideration for applying with the JBC for possible selection, your professional advancement.
Yes, Your Honors, and beside it's my dream to be at the Supreme Court, if God will permit me.
Justice, you mentioned that you have a zero backlog. And I also noticed in your personal data sheet that, well, according to it, you have a 99% affirmance of your decisions. Is that correct, Justice?
Well, it came from our database, Your Honors. I don't. That's why I was also surprised. That's why. Most of us, okay, would like to have a speedy disposition of the case. I tried, but sometimes you also take into consideration the quality of a decision. Okay, So should there be an affirmance, I believe what I might have rendered is a quality decision. There might be some other judges that they work past than I am, but I would like to think of their affirmance. And I learn a lot from the legacy of then Chief Justice Fernan, who introduced the continuous trial, as well as to use the preliminary conference and pre-trial, wherein the judge would always participate in the simplification of issues, as well as to limit the number of witnesses to be presented. Those are material matters supposed to be done by whoever is the presiding justice or presiding judge of the court. Your Honors.
Justice, could you name one or two major cases that you penned or decided that probably became a high-profile case or landmark case of the Supreme Court?
Well, I would like to think this is without necessarily having I think in the case of the member of the Abu Sayyaf, wherein the private complainant or the victim was an American, the decision there is conviction for a plain life imprisonment without imposing death penalty. Why? Even the U.S. Embassy, the DOJ prosecutors have asked for a while, Judge, is that correct? Because the information states kidnapping for ransom. I just tell them, go ahead, go to the Supreme Court, because you read it carefully before you complain. The same as being affirmed by the Supreme Court. That is, I remember now, Robert Schilling is the victim. During another thing is the probate of the will of ex-President Marcos. In that probate, my resolution appointing two administrator was affirmed in toto by the Supreme Court. That is somewhat unusual, because in my resolution I suggested to have an appointment of one of the heirs to be named by the Marcos family and Undersecretary of the DOJ to be named by the Secretary in order to protect the rights and claim of the Philippine government. The same is being affirmed by the Supreme Court, Your Honors. But at present, high-profile cases, we have before, when I was still a junior justice, I participated in the case of Enrida. Now, Congresswoman Leah Chon, and the case of General Sani Razon. And I know at this time they are filing an motion to avail of their bail, Your Honors. Those are, to name a few.
Yes. Justice, you mentioned, pardon me if I understood you correctly, did you say earlier that you imposed the death penalty several times before when you were judge?
Yes, Your Honors.
Because at that time, of course, the death penalty was still in the law books, meaning it's something that can be imposed.
Still effective, Your Honors.
In other words, Justice, if there is a move in the future, in the near future, for the restoration of the death penalty, you'll definitely suppose it if your comment or recommendation is sought?
Yes, Your Honors, I still maintain that. To initiate that penalty, I will not. But to agree to imposition of death penalty, I agree, Your Honor.
Justice, I'd like to propound this question again because these two of our earlier applicants have tried successfully to evade answering this question. So I'd like to find out whether you'd be courageous enough to offer an answer. Hypothetically, the facts are undisputed. Person is of age. He is born under the 1973 Constitution. He is admittedly a foundling, biological parents unknown, and he is running for the presidency. Would he be qualified on the basis of whether or not he is a natural-born Filipino citizen?
Actually, the President, I will answer that, Your Honor. I am very, have that guts. Although I might be deprived to participate if I'll be lucky to be a member of the court. But may I have your indulgence on this matter? Because before I have my bar in 1983, I talked to Justice Bitog regarding this question. Sir, a Filipino natural-born citizen joined the Navy, and then consequently became a U.S. citizen. Upon retirement, I went back and seek the advice of a lawyer. If you are the lawyer, supposing this is a question in the bar, if you are the lawyer, could he run as member of the National Assembly? The Constitution states that a member of the National Assembly must be a natural born. But Justice Bitog did not answer me. What he asked me, Alex, ano ba alam mo? Well, it's because of this, sir. There are two schools of thoughts. In accordance to Justice Roberto Martin, it says, a natural-born citizen must have that citizen by birth without performing any act. So therefore, naturalized, he could not be a member of the National Assembly. While Justice Mendoza claimed what he reacquired is his former status. Justice Bitog suggested to me, should you answer that, you go to the third paragraph. I submit, and then it's up to you then where to argue, the first or the second. Now, I will now answer. Since I now matured, I would like to say, because at that time, I was about to take the bar, since I'm now matured, well, I would not use the word legally speaking. I use the word constitutionally speaking, sad to say, that Filipino Navy, should I use my example, who reacquire his citizenship is disqualified to run because being or acquiring, performing an act, it would constitute the specific definition of a naturalized. Even assuming further, Your Honors, should that Filipino citizen, this is my view, because the opinion, should I be at the Supreme Court, even perhaps the dual citizenship law, should it be assailed, whether it's constitutional, I would say it's not. Because under the Constitution, there must only be one allegiance.
Justice, that is not my question. My question is about a child whose parents are unknown, foundling.
Okay. Well, if in my limited knowledge, because I think we could, or I might base it in the 1930 Hague Convention. One of the sections there, if I'm not mistaken, Section 14 of that convention would state that a foundling must have a citizen, but not necessarily to be a natural born, where that child being found. Section 15, I think, if my limited memories will serve me right, would say the country where is the foundling was found have that way or system to determine what kind of citizenship he or she must be. So, I would like to think it might not be the Philippines, because the Philippines is through our true blood. Other country through territory. Just like in the States, where you're born there, you will be considered natural born. So, in the case of Grace po, notwithstanding she is a Filipino citizen, she could not still be considered a natural born citizen.
Thank you, Jesse.
May I still add? Because we have been so specific about it. The problem in that case is there is renunciation. That's the problem. When she reacquired the citizenship, she falls now to the definition of naturalized, even assuming she could be natural born. Thank you, Your Honors.
Thank you.
Thank you very much, Attorney Guevara. How about Justice Lagman? Do you have questions for him?
Thank you very much, Madam Chair. As stated in the records, we have interviewed Justice Quiroz several times already. I think I only have one question for Justice Quiroz. If you are a member of the JBC, what would be your criteria in selecting the nominees for the post of Associate Justice of the Supreme Court?
Well, first of all, should I be a member of the JBC and I wish to have a quality composition of the Supreme Court, then I will use that such my examination and evaluation. First, my first priority is to look into the integrity of that person. 2, work attitude perhaps. 3, competency, and the competency perhaps might be also likewise be coming from the experience. Because are we not talking JBC screening the Associate Justice of the Supreme Court?
Yes.
Now, because the member or magistrate of a Supreme Court is not isolated in decision making, there are likewise so many administrative matters to be taken by the member or the magistrate. One of which is the how to what are the necessary procedures to be amended, or what are the steps to have an efficient. So the nominee must have full of experience so as to know what are the requisites, not necessarily to have an academic excellent, because I still maintain that experience is still the best professor. So a well-experienced applicant will have, just like me perhaps, have an edge. And then work attitude, and those are the qualities. Perhaps the leading qualities are three: qualifications, integrity, and then competency. Your Honor.
No further question. Good luck, Justice Quiroz.
Thank you, Your Honors.
Thank you very much, Justice Lagman. Just one question.
Opo, yes.
Give me 2 or more decisions decided by the Supreme Court wherein you could have dissented if you were already a member thereof.
Well, although I'm no longer there in that division, in the Enrile case, Your Honor, because first of all, based on my experience, there are so many trial judges being sanctioned to be removed from office for granting a bail without hearing. But taking into consideration sometimes, especially a petition to post bail filed by the accused movement, supposed to be the presiding judge or magistrate must always be aware the conduct of hearing must be summary in nature. There are so many things to do it. I cannot. At that time, I would like, because the plunder case at present, the plunder case, the prosecution is trying, because summary nature, the prosecution should only show the evidence of guilt are strong. But in this case, no more. They are as if they are presenting the evidence in chief. So it will really take long. Now, I'll give you one concrete example. I asked the prosecution to give the list of witnesses. I noticed, for example, but no, this is not example. I noticed, just like in the case of Liachon, I asked the prosecution, who is this representative from the House of Representatives to be presented? Your Honor, he will testify that accused Liachon is a congresswoman. My goodness. Let's ask the other party. Do you deny that the accused is a congresswoman? The answer is no. So my point, the presiding judge should they only participate actively, it will lessen the burden of everybody. Okay? Now, the reason why I will dissent to the case of Enrile, first of all, humanitarian reason is I could not find it in the rules of court. I'm sorry to Manong Enrile.
You are correct. I agree.
Likewise, the age, because if we will follow the doctrine of res ipsa loquitur, the medical records, since I have seen the records of Manong Enrile, well, I think PGMA is more worse of her situation. So she should also be given same chance. However, I noticed in the case of Manu Enrile, I noticed that they're asking something which perhaps might open the door of the Supreme Court to revisit the rights of the accused in the presumption of innocence. Because normally, should there be a non-bailable offense, they have to file a petition. Why could I might able to suggest this? Why could we not reverse it? The prosecution will prove that the guilt of the accused are strong before we deprive a person of his right to bail. Which these are two things to be balanced by a magistrate. Just like speedy disposition against quality decision. There is compliance for the first and second level courts of 90 days. but the quality been sacrificed. In the appellate court, just like in the Sandigan, as much as possible, we would like to make it 1 year. But the problem is, I do not expect all situations are equally situated now. So, those are the things to be balanced. Now, insofar as, because I read a lot with regards to the case of Senator Enrile, they might be asking something correct, but procedurally not correct. Number one is that way. Number two, they're really asking as if a bill of particulars. During that trial, I even mentioned to both of them to be more specific as to what kind of evidence to be presented. Okay? But the problem is, I cannot be a defense counsel for Senator Enrile. I could not neither go with the prosecution. They should pick it up from there. Now, that's the problem of the present pending cases before the Sandigan Bayan, because the almost all division allow the prosecution to present their evidence by way of opposition to the petition to post bail by offering the entire evidence. So it's unfair, supposed to be. I think those are the things. But should you now limit the prosecution, they might brand you as if you are depriving them to present the evidence that might cause the granting of the bail. So you have to balance, Your Honors, the things that to be considered. But going back, Your Honor, I will dissent to the Senator Enrile as well, because it surprised the judicial community, Your Honors.
Because the grounds relied upon by the Constitution are not provided for by the Constitution or the rules.
Yes, Your Honor, and besides, there must be a hearing.
There was no hearing yet, and the prosecution was not given a chance to present its evidence to determine whether or not the evidence of guilt is not strong. Anyway, thank you very much, Justice. We wish you good luck.
Thank you very much, Your Honors.
Good luck.